Good afternoon, Justice Kagan. My name is Crystal Inekwa. My question is it difficult for you to separate your personal beliefs from applying the law to cases, and how do you manage to maintain that separation?
Well, I think it's really important to maintain that separation. You know, I'm a judge, and my job is to interpret the law and to apply the law. Now, that's often a hard task, right? Because it is often the case, at least the cases that come to the Supreme Court, which are, you know, the hardest cases, where the law is unclear. It's ambiguous in some kind of way. There's some kind of gap, which makes it not crystal clear exactly what the law is. But it's really important that in resolving that ambiguity or in filling that gap, that what you not do is import your own thoughts about what would make for a good society. So think about it first. I mean, our cases fall in two groups, generally. One is statutory cases and one is constitutional cases. So think of a case where Congress writes a statute, and Congress has not expressed itself clearly as to some matter. And the question is, you know, how do we interpret and apply the statute when Congress has not given the world's most lucid instructions? And there are lots of different approaches to that, but one very bad approach would be for me to say, well, what would be the statute I would like to write? You know, what do I think a good statute would be? What do I think the real problem? That's a terrible way, all right? So now there are different views about how you deal with ambiguity in a statute. You know, some people just say, I'm going to look only to the text, and I'm going to get everything I can from the text, but I'm not going to, and I'm not going to go any further, even if that leaves, even if I know that even if I feel as though the text doesn't completely answer it, that's the only place I'm going to look. Other people will look to legislative history. Other people will try to explore legislative purpose. There are a whole number, other people will use what are called canons of statutory, but there are a whole number of interpretive techniques to try to figure out what Congress meant. And people will disagree about which techniques to use, and sometimes people will disagree about the application of those techniques. But I think what none of us do is to say, well, who cares about what Congress thought? Congress has not spoken very clearly, so I have the ability to write a statute of my own. That's not my job. And I have to know what's my job and what's somebody else's job and have a very clear separation between those two. The same is true with constitutional interpretation. Constitutional interpretation is often really hard. I mean, what does it mean to make no law abridging the freedom of speech? What's an abridgment? What actually is the freedom of speech? What does that allow and what doesn't it allow? What does equal protection of the laws mean? Now, those we see cases that force us to say, here's this constitutional language. How does it apply to a particular case? And again, there are different methods of doing constitutional interpretation, different emphases that people give to texts, to history, to precedent, and so forth. But one thing that would be completely wrong would be to say, well, here's my view of the perfect Constitution, or here's my view of justice, justice. That's not the task. The task is to try to give the best reading possible to the Constitution, just as much of law as a statute, just like you wouldn't make up your own statute. You can't make the Constitution mean whatever you might think the best Constitution would mean, right? So I think that there's a real division of function that a judge always has to think about. And And doing law is often hard. It's not very, especially, you know, at the Supreme Court where we get the hardest cases, it's not mechanical. And there are often disagreements, but what you're doing is law. You're not doing something, you know, you're not doing the things that, you know, that you would do as a politician, and you're not importing your own concepts of good and bad and right and wrong and just and unjust.